Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-1226. Talfi Gulf and Sierra Club petitioners versus Federal Energy Regulatory Commission. Mr. Bookbinder for the petitioner, Mr. Shaner for the respondents, Mr. Rosenkrantz for the interveners.
Good morning, Mr. Bookbinder.
Good morning, Your Honor. My name is David Bookbinder, and I represent the petitioners in this matter. And this morning, I would like to talk about 4 of the claims that we have in this case. 2 are under the Natural Gas Act, and 2 are under NEPA. Our Natural Gas Act claims, first, that it was arbitrary and capricious for FERC to find that 2300, I'm going to abbreviate pipeline 200-300, simply 2300 for ease, that it was arbitrary and capricious for FERC to find that 2300 serves a public inconvenience and necessity while knowing and never disclosing that its actual purpose was something else entirely. Our second Natural Gas Act claim is that FERC failed to balance the impact of 2300's greenhouse gas emissions against the project's benefits. Our 2 NEPA claims are, first, segmentation, that FERC failed in its NEPA analysis to analyze the impacts of the terminal along with the impacts of 2300. And our 4th claim is that FERC failed to analyze the impacts of upstream greenhouse gas emissions from the production and transportation of the gas through 2300 that would be burned domestically. First, on to need. A little history. In 2019, FERC approved the Driftwood LNG terminal and the mainline pipeline to supply it. The mainline would supply all of the terminal's needs, and the terminal subscribed to 100% of the mainline's capacity. 2021, Driftwood comes along and applies for 2300 and says in their application, the project has been proposed to provide enhanced supply access to the natural gas market in the Lake Charles, Louisiana area. That purpose was then repeated in the draft environmental impact statement and again in the final environmental impact statement. We get to the certificate, and when FERC issues the certificate, all of a sudden, for the first time, FERC says that 2300 is, quote, designed to enhance and further diversify Driftwood LNG's access to natural gas supply. And when not being used to supply the terminal, the project can improve the Lake Charles, Louisiana area's abilities to access gas. This is the first time that FERC said anything about the terminal needing a second redundant supply line. What was going on? Well, it turns out that FERC disclosed something in a completely separate docket, in a docket dealing with the LA storage facility, which is a Section 7 project. And in the certificate in that docket, FERC revealed that the 2300 and the terminal would be built simultaneously and operated as a single project. And the main line would only be built years later, after the terminal and 2300 were built and operating as a single project for close to 8 years. Then Driftwood.
So counsel, assume all of that is correct and that 2300 is going to be built before the main line. How does that help your case on market need? Wouldn't that just show there's even more of a need for 2300?
No, Your Honor, it's the point that this was not disclosed, that the need for the project, well, the ostensible need in the application and the DEIS and the FEIS was Lake Charles. The certificate says it's going to be a backup to the terminal, it'll be backup to the main line. Now we have a situation where it turns out it's going to be the main line's supply for many, many years, not as a backup. So even their rationale in the certificate doesn't hold water. And to clarify, our claims are not based either on the bait and switch between the application and the environmental impact statements and the certificate, or in fact, the lack of support for either of the two rationales in the certificate, the need for a more diverse supply, or the Lake Charles need. We point to those merely to say the lack of evidentiary support for those alleged needs supports our claim that neither of those was what Driftwood intended with this project. Those confirm what FERC said in the LA storage certificate, that this project was, that 2300 was being built as the terminal supply, period. Our second Natural Gas Act claim is that FERC failed to weigh the greenhouse gas impacts of 2300 against the need. FERC claimed it only needed to disclose 2300's emissions, go through the social cost of carbon multiplication for informational purposes, and then say it's 2300 serves the public convenience and necessity. And that's exactly what this court rejected just weeks ago in New Jersey Conservation Foundation, where the court said FERC asserts that it adequately weighed the potential environmental harms of the project just by disclosing the project's reasonably foreseeable greenhouse gas emissions. But FERC nowhere explains whether and how the commission considered those emissions among the adverse effects it balanced and found to be outweighed by the pipeline's expected benefits. That is exactly, precisely to the letter what FERC did here. On to the...
What about Food and Water Watch? That was also recently decided.
Yes, sir. The Food and Water Watch talked about other aspects. It said you don't have to use the social cost of carbon. It didn't say exactly what New Jersey Conservation Fund said. Regardless of what you do in terms of your NEPA analysis, under the Natural Gas Act, you still have to weigh those impacts. Food and Water Watch.
How do you measure what the impact is on the climate, the worldwide climate, by putting in a 30-mile pipeline?
Your Honor,
How is that possible?
it's possible by using, in fact, that social cost of carbon tool or some other tool. The Natural Gas Act simply doesn't say, well, there's an impact, but we can't, FERC can't
It's
say.
not even clear there's an impact of CO2 on human-made CO2 on climate anywhere.
Respectfully, Your Honor, I think that is, that's not an issue in this case, and FERC assumes that it does. FERC agrees that there is a CO2 impact on the climate, and FERC simply waved its hands and said, we can't discuss the magnitude of this under NEPA. We can't say whether it's significant or not under NEPA. But regardless of it, whether it's significant or not under NEPA, FERC has to consider it somehow in coming up with an answer as to whether or not the project's benefits outweigh its impacts.
So for that argument, is there some affirmative indication you see that FERC did not consider the greenhouse gas emissions? In
its Natural Gas Act analysis?
In the Natural Gas Act analysis, it essentially references and incorporates the EIS in its entirety. It says, we concluded it's environmentally acceptable, and then it makes the Section 7 finding. And I guess the question is, how do you know they didn't think about GHG emissions or didn't think about any of the other many environmental impacts listed in the EIS?
For two reasons. One, in the EIS, they say, well, we're doing the social cost of carbon calculation for informational purposes. There's no indication that they're going to take it into account in their own weighing when they say it's for informational purposes, not clearly for agency regulatory purposes. Moreover, it's exactly what they did in that this court rejected in New Jersey Conservation Foundation and in FERC's brief. It says all we have to do is disclose the emissions and cite the benefits of the project. And that's it. We've done our duty in terms of weighing the greenhouse gas impacts against the need for the pipeline. And that's exactly what happened here, almost word for word. On to NEPA. Our first NEPA claim is segmentation. When FERC approved the terminal and the main line in 2019, it approved them with a single EIS as a single project. Now, LA Storage tells us that Driftwood is going to build the terminal and 2300 as a single project built simultaneously. They'll be completed simultaneously. They'll be operated as a single unit. Therefore, FERC should have taken into account collectively the impacts of 2300 and the impacts of the terminal.
What language of NEPA are you relying on?
The connected action language of NEPA.
Connected action.
Yes.
That's in NEPA?
Yes, sir, it is.
Yeah.
NEPA says you have to take into account connected actions, and 2300 and the terminal are absolutely connected actions, the same way that FERC said the main line and the terminal were connected actions.
So you're not relying on CEQ regulations?
Well, yes, sir, it is CEQ regulations that require that you analyze connected actions together.
Where does CEQ get the authority to issue regulations?
In the National Environmental Policy Act.
No, it's not in there.
Then I don't know where CEQ gets the authority to issue
That's
this.
from an executive order that was issued in 1977, I believe. Can an executive order authorize an agency to issue regulations?
Well, since it's been close to 50 years of CEQ issuing such regulations, and I'm not aware of any court saying that CEQ did not have this authority.
This court has said it about 5 times, and said that it's doubtful that CEQ has any regulatory authority.
Oh, that was not an issue that was presented here. FERC did not.
I know, it's a separation of powers question, which can be raised by the court itself.
I don't dispute that you can raise it. I'm just not prepared.
I'm raising it.
I am not prepared to argue or discuss CEQ's authority and separation of powers. I'm sorry, that's simply something I didn't prepare for. So
Can you address the argument that your current segmentation claim is forfeited? So I think what FERC says is you actually were on notice that about the construction timeline that is now the basis of your claim. And it seemed like in your briefing, you conceded you didn't raise this during the comment period before the agency.
we didn't raise it in the comment period. So as a NEPA issue, NEPA excuses things that are justifiably omitted, but more importantly, as we know from Public Citizen, is something that is so obviously, glaringly omitted, and other courts have said, and if something is already known to the agency knew and published in one of its own orders that the terminal and 2300 be built together. Now, the issue of waiver.
They did not know that you were arguing that for that reason, it was a connected action and that they needed to reissue an EIS fully addressing, the combined impact of the terminal and this project.
As I said, Your Honor, there is precedent, including Supreme Court precedent, that says, if something is such a glaring omission, or as this court and other courts have held, if something is obviously known to the agency, there's no need to raise it for purposes of NEPA. We did raise it in our rehearing petition. So it is preserved in terms of review in this court. So I want to draw the court's attention to the Delaware Riverkeeper case, where the court pointed out that the project in front of it and a previous project, a previously approved project, were linked, saying the temporal nexus is clear. Tennessee Gas proposed the project while the pipeline was under construction, and FERC plainly was aware of the physical, functional, and financial links between the two. This was even more egregious. The first project in Delaware Riverkeeper was under construction. Here, the first project, the terminal hadn't even broke ground when FERC knew that the terminal and 2300 would be constructed together. Finally, I'd like to talk about upstream emissions. There's two issues, one legal and one factual. I don't think there's really a legal dispute that FERC's obligation only goes to the portion of the gas 2300 will carry the upstream emissions of the portion of the gas will carry for domestic consumptions, which is 1.5% is the number now. The factual issue is that FERC says to do this, it needs all sorts of information. Location of the supply source, whether the gas would come from new existing production, et cetera. And we gave them precisely that information. We gave them the quotes from Tellurian's. Tellurian is the parent company of Driftwood LNG and the Driftwood pipeline. Their head of production said, we plan to drill 13 wells in the Haynesville Shale that will operate as it looks to build sufficient feed gas supplies to support the first phase of the proposed Driftwood export terminal. And then Tellurian's head of production the next year said, we're purchasing another 5,000 acres in the Haynesville Shales, where these assets provide Tellurian with both cash flow and a physical hedge for the Driftwood terminal.
Your time's expired. I'll ask if you just can bring a conclusion to your opening remarks. I'll give you some time on rebuttal.
Thank you, Your Honor.
May it please the court, Houston Shaner for Respondent Federal Energy Regulatory Commission. And I'd like to start with the most extreme claim in this case, and that's my colleague's assertion of some sort of deliberate concealment or deception by the commission. There are at least two major problems with this argument. First, it's forfeited. In fact, it's been forfeited twice over. If you refer to the rehearing request for agency rehearing by the petitioners below, and you look at their needs section, that's J 711 715, you will see no theory about the commission deliberately hiding the true purpose of the terminal, or I'm sorry, of the project to supply gas to the terminal for exports until the certificate order. In fact, you won't really find any sort of conspiracy theory whatsoever. They merely attack the idea of redundancy. And if this were such a dramatic bait and switch by the commission, you would certainly expect petitioners to make a big deal out of this in the rehearing order, but they did not, and so it's jurisdictionally forfeited. Worse, it's also forfeited at the appellate level. While they make a lot of this argument and this theory in the reply brief, it's simply not found in the opening brief whatsoever. They say that there might be some different purpose, there might be a replacement of the main line with the project, but they never make any allegations of concealment or deception by the commission, and no argument about a bait and switch until the certificate order. So this claim fails at least two threshold levels. But even worse still is the fact that it's simply patently wrong. Much of this material is recounted in the responses to the motion to supplement the record, which this panel may or may not have reviewed. It's not clear who decided it, but I'm happy to walk through those. Starting with the first half of the executive summary of the application by Driftwood submitted to the commission back in 2021, JA4, they say that the project runs from the Ragley area all the way to a final interconnection point and meter station 12 within the footprint of the Driftwood LNG facility. Any reasonable reader would understand that to mean that the project can deliver gas to the terminal. If that weren't enough, you then move to resource report 1 in the application, JA38, where they say explicitly the project can deliver gas to the terminal at that interconnection point. And then again in resource report 10, JA92. If the application weren't enough, Driftwood then confirmed that fact when they disclosed the foundation shipper, Driftwood LNG, in JA160 through a data request to the commission, and then again in the answer at JA143. And then again at JA157 in the answer as well. So it's clear that the petitioners were on notice far, far before the certificate order, in fact, roughly 2 years before the certificate order, that the project that runs to the terminal might supply the terminal. But they're banking not only their need argument, but also their segmentation argument on that fact. And not only is it forfeited, but it's patently wrong. I think more fundamentally, their argument on concealment and need simply misunderstands how substantial evidence review operates. The commission makes a finding that the market in Southwest Louisiana can support 2 new pipelines, even if one is redundant to the other. As long as there is some evidence supporting that inference, the commission's result can be sustained and is conclusive under the Federal Power Act. And as laid out on pages 32 through 34 of the red brief, there clearly is a great deal of evidence in favor of redundancy and reliability need for that particular market area. That includes the precedent agreements, industry practice, or multiple industry practice, or practice across multiple industries, as well as corroborating comments from large industrial players like Entergy. At the same time, there is simply no answer to the market study evidence supporting the need for non-LNG gas supply to the Lake Charles area that is simply unanswered in both the opening brief as well as the agency rehearing request. And I don't hear any response to that in my friend's opening argument as well. But that simply means that as long as there's some substantial evidence on project need, this court can affirm. But affirming on those same ground means that the segmentation claim necessarily fails as well, because their only excuse for forfeiting this argument below, not raising this concealment theory during the NEPA process, is that they claimed they couldn't have known that the project was going to deliver gas to the terminal, but obviously that's wrong.
Today, they're saying that it was just so obvious. Maybe if you recognized that 2300 was going to supply the terminal, it's just obvious that in the same way the main line and the terminal were considered together, this should have been considered together with the terminal. What's your response to that?
Well,
Potentially new argument.
sure. If I'm understanding you correctly, we're getting more to the merits rather than forfeiture there.
No,
Forfeiture.
his response to my question about forfeiture was that there's an exception when the matter is so obvious to the agency that there was no need to raise it in a comment.
Well, I'm not sure the case law necessarily says that, because the 2020 CEQ rule, which is mandatory and at least binding on them, assuming, Judge Randolph, putting aside Judge Randolph's arguments, they had a specific duty, to raise this issue specifically at the EIS stage, but they failed to do that because the commission is entitled to be put on notice of this argument, particularly something as striking as the idea of a deliberate concealment and the
You're relying on that CEQ rule?
within the context of this argument, Judge Randolph, but certainly
It's been repealed, hasn't it?
that rule has, yes. But at the time of the certificate order, it was still
But it
active.
was in effect when when this.
Correct. A new rule replaced it, I believe.
And why did CEQ repeal it?
I could not give you all of their
You
reasons.
said it's none of their business to tell the courts how to act.
That may be part of it. At the time of the certificate order, though, that rule was in effect. And I would also note that if your separation of powers claim is correct, then their connected action argument goes away entirely. We don't need forfeiture because it depends entirely
I
on the
thought one of the
CEQ.
most compelling arguments that I don't hear you making now is the point that the commission made in its decision that unlike the usual situation, the terminal, an LNG terminal, has no captive customers. So if they're going to build a pipeline to the terminal, they're not going to be able to do it for free by passing the costs on to the captive customers. And so that leads to the conclusion that the only reason that they'd have to be fools to construct a pipeline when they don't need it, according to the petitioners, because they can't pass the costs on.
That is exactly correct, and is exactly why Environmental Defense Fund 2021 is distinguishable in this case.
Right.
And I think it's open and shut. They have no real attack on paragraph 24 of the certificate order.
Right, I've read it.
Now, I'd also like to move to NEPA significance and what they call the Natural Gas Act balancing argument. New Jersey Conservation Fund is clearly distinguishable on the NEPA front because they have never at any time raised a Northern Natural argument based on that precedent, so there's no similar failure to explain. In fact, on NEPA significance, this case is exactly like Port Isabel, where they raise an argument along the style of Vecinos, and Port Isabel affirmed a materially identical explanation. They try to shift this argument into a more fuzzier and general Natural Gas Act argument, saying you have to use social cost of carbon to balance costs and benefits under the Natural Gas Act. This court has never held that. In fact, this court affirmed in both Alabama Municipal and Food and Water Watch the commission's explanation in those cases and here, the social cost of carbon is not fit for project level review. They've never had any persuasive authority to distinguish that or any reason why we have to use it for each project, each individual project. In fact, that's never been the case. And in fact, that goes back to Center for Biological Diversity and the 2022 Delaware Riverkeeper Network decision, which at 115 says that once the commission properly conducts an environmental analysis under NEPA and incorporates the EIS, as Judge Garcia mentioned, then it has reasonably concluded that the benefits of the project outweigh the costs. And that's all that this court has required. And Judge Wilkins, I would also note you're exactly correct. Food and Water Watch cleans up any possible other NEPA or Natural Gas Act arguments. about the social cost of carbon because there is no need to make an up or down call about significance for individual impacts. And that's clear.
Could you just briefly address the upstream emissions argument?
Certainly.
And
I was turning there now.
Yeah.
So
I just started with the letter that
so I-
says the 13 wells and explained why.
Yeah, so we need to take those letters individually. They now can see there's no legal causation over exported gas, but that removes any relevance of the press release at JA 14 and the Weber article, which mentioned the 13 wells at JA 422, because those articles, they mention tellurian holdings within the Haynesville Shale, but they do not say that it's even going to the project, and they only suggest that the gas from the tellurian wells will go to exports. But that means it's already been carved out of any realm of legal causation. Well, originally by Earth Reports in 2016, which was about the Section 3 and Section 7 case, but more recently by the 2024 Alabama Municipal decision that very clearly says that a Section 7 pipeline sending gas to a Section 3 facility for export is not the legal cause of upstream emissions. That leaves only the Baker article, which is sandwiched in between those. That's a JA 416. That does mention the project. But here, it does not say that tellurian is going to drill any wells in any specific basins. In fact, it says that the project, part of the point of the project, is to source gas from multiple producing basins around the country. You'll see that in the map on page 12 of the red brief, literally half the United States. But even if that doesn't fail on legal causation, it clearly fails on foreseeability grounds under Burkhead and more recently under the 2024 Food and Water Watch decision, where the Marcellus Utica shale was too large to be able to attribute foreseeability to upstream emissions. But this case involves not only the Marcellus Utica shale, as that map demonstrates, but also 5 or 6 other gas shales around the country. And I see I've run out of time, but I'm happy to answer any other questions the court may have.
All right, thank you.
Thank you.
We'll hear from Mr. Rosencrantz.
Good morning, Your Honors, and may it please the court, Josh Rosencrantz representing the interveners. Your Honors, just a few points really by way of framing. I'll add to Mr. Shainer's point about this accusation of collusion because petitioners are building both their segmentation argument and their need argument around the notion that FERC colluded with Driftwood to hide from the public the actual planned sequence, and that is their excuse for forfeiting the issue. In addition to the points that Mr. Shainer made, let me just point out that it is clear on the record in this docket, forget about the Hackberry certificate. In this docket, FERC and petitioners knew full well that we planned to build the line 200, 300 before the main line. We said it in a filing on the public record on February 22nd, 2022, sorry, February 11th, 2022, while the application was pending. Now, it's not in the joint appendix because petitioners did not raise this until their reply, but it is at accession number 2022-0211. That's the date 5221. And in that document, we very clearly laid out the sequence. First comes line 200, then line 300, then the main line. Second framing point, listening to—
line duplicate the 203 line, 300 line?
Does the main line duplicate the 200, 300 line? No, Your Honor. They provide separate purposes. The 200, 300 does supply optionality to the terminal, but it also is designed to supply the market. And I would note that petitioners are completely ignoring the market study that says that there is an enormous demand. And I think really listening to the argument today, I realize there's an enormous disconnect because petitioners are pointing to the 92% that Driftwood LNG is subscribing to. And they are saying incorrectly that is only for the terminal. Driftwood LNG owns a terminal, yes, but it is also a market participant. It is going to be selling the gas to the market when it doesn't need to provide the gas to the terminal. So 92% that Driftwood LNG subscribes to is a really, really expensive expenditure, to Judge Randolph's point. It's way more expensive than the gas itself, and there's no way they would be subscribing if they did not plan to use the capacity to supply the market. Third major point, for all of these protests, it's worth asking petitioners, what exactly do you want FERC to do differently on remand? FERC already performed a full environmental impact statement and analysis on the main line and at the same time on the terminal. It performed a full environmental impact statement on line 200, 300. And then when it was analyzing line 200, 300, it analyzed all three together by way of cumulative effects. Finally, I need to underscore a point that has not come up, but petitioners emphasized by way of citing Transco, the NJCF case, and Port Isabel. If this court perceives any error in FERC's order, it should at most remand without vacating. First, the commission will almost certainly reach the same result for reasons that I've already mentioned. And second, vacatur would be downright disastrous. I know that shovels have not hit the ground yet on line 200, 300, but they hadn't hit the ground yet in Commonwealth either. And this project, as in Commonwealth, presents years of planning, massive financial investment, complex coordination among industry participants and government bodies, and killing the project, or at least postponing the project, I should say, could amount to killing the project and the jobs that come with it. I would note that FERC found an urgent need to supply gas to the Lake Charles area, and vacating the order will only delay the satisfaction of that need to the detriment of the public and the consumers and businesses.
Or we could vacate and then stay the order.
Your Honor, I would urge the court not to, because that is the equivalent of a remand. Because if you're staying the effect of the vacatur, you could achieve the same thing simply by remanding. And I would underscore the point that a vacatur is just hugely disruptive, way more disruptive than simply a remand telling FERC to go back and do its work differently or better. For these reasons, Your Honors, we respectfully request that this court reject the petition.
Thank you. All right, Mr. Bookbinder, we'll give you 3 minutes in rebuttal.
Thank you, Your Honor. First of all, as to the needs argument, as I said before, the flaws with the market study, the fact that FERC engaged in a bait and switch, and the issues surrounding whether there's factual support for the idea that the 2300 would bring a diverse supply to the terminal that mainline would not. Those are not our arguments. We are not saying that those are, that makes the FERC's findings arbitrary and capricious. We're pointing those out as evidence supporting our claim that this terminal was meant for another purpose entirely. It wasn't meant for either of those purposes. Now, on the segmentation claim, the Driftwood says, we told them, it's in the record, that we're going to build the main line after 2300. Yes, in the 28J reply, filed about 10 days ago, they pointed to a 924-page document. They didn't tell us what page in that 924-page document to find this statement. And we found the statement. It's in a section dealing with engineering issues, and FERC asking about engineering of, if you're going to be building some part of 2300 where you're going to build the main line, how are you going to do this properly under engineering principles? And then they say that they're going to build the main line afterwards. It doesn't say they're going to build 2300 and the terminal together. As far as anyone would know, the terminal gets built, 2300 gets built, main line gets built. They get built together, or as they're insisting, we're building 2300 to serve the Lake Charles market. Okay, then you build 2300 and then you build the terminal and the main line. You can't tell from a statement simply that they're going to build the main line after 2300 when they're going to build the terminal. That's our segmentation issue, terminal and 2300 together. The issue is, what would a new environmental impact statement look like? Well, two things about that. First of all, the purpose and need of the project statement would look a lot different. The existing one said, if this is 2300 is designed to supply the Lake Charles market. That purpose and need would look a lot different. It was 2300 is designed to be the terminal supply of gas for at least 8 years and who knows how much longer beyond that. More importantly, the alternatives analysis would be remarkably different. If a new EIS says the purpose of this project is to serve as a backup supply or more diverse supply, et cetera, any sort of supply to the terminal, the alternatives analysis would begin with, well, FERC has already approved a pipeline to supply this terminal. Those are things that are simply don't exist in the current EIS. The gas for export issue on upstream, you can't separate out the gas a pipeline will carry that's being carried down to the terminal. You can't say, this is the gas, we have a separate source of gas for the domestic use and the rest of this gas is going to go for export. Once those driftwood wells, that gas goes into that pipeline, it gets intermingled, and then you don't know, you can't separate out the molecules that go for export from the molecules that will be used domestically. Last is the idea that you can't use the social cost of carbon for evaluating the impacts of greenhouse gases at the project level. I have never seen an explanation from FERC why this is so. They keep saying it's good, it's okay for doing at a regulatory level, but not at a project level. I have seen no explanation from FERC ever as to why 40 tons or 100 tons of greenhouse gases emitted by a project is qualitatively different from the same amount of that gas when it's emitted as a result of a regulatory action. I see my time is up, Your Honor. If there are no further questions, we ask you to vacate this certificate and remand to FERC.
Thank you. We'll take the matter under advisement.
Case number 23-7109 et al. Elisabeth, Regina, Marie, Gabrielle von Pezold et al. Versus Republic of Zimbabwe appellant. Mr. Smith for the appellants, Mr. Paparella for the appellees von Pezold et al., Mr. Zaslowski for the appellees Border Timbers et al.
Morning, Mr. Smith.
Good morning, sir. May it please the court. My name is Quinn Smith. I'm here on behalf of appellant. I would like to make one note. I am joined by the Attorney General of Zimbabwe, who is here to my right, Ms. Mabizo. Your Honor, this is an appeal about two sets of treaties. There are limitations on any waiver of sovereign immunity and the interaction between those sets of treaties and the Foreign Sovereign Immunities Act. Now, the first set of treaties are the New York Convention and what we call the ICSID Convention. And they are useful for analyzing the implied waiver in 1605A1. That's going to be the first set of treaties we discussed. And the second set of treaties goes to the so-called arbitration exception. And that's 1605A6. So let's look at the first set of treaties. The district court erred when it found that Zimbabwe's ratification of the ICSID Convention was an implied waiver of its sovereign immunity.
Why don't you start with the arbitration exception? Because if we reach that, we've held that we don't need to reach implied waiver, right?
You are correct,
Got
sir.
recent precedent like Next Era.
Yes, sir.
Seems that precedent's difficult for you. Why don't you tell us why we shouldn't follow that here?
Absolutely, sir. I'll go to the arbitration exception. If you'd like to hear about the implied waiver, I have a few new things. But on the arbitration exception, we're looking at what the instruments are that created the consent, and those are the treaties. And these treaties are unique. They're different. There's language regarding how the award should be enforced. And we don't see this kind of language in other sets of treaties. We really don't see in other sets of treaties with Zimbabwe, perhaps a little bit with Germany, but certainly not in other countries. And that language has very exacting terms. So for example, if we look at the Swiss treaty, section 10.6, the award, quote, shall be enforceable in accordance with the laws of the contracting party, capital C, capital P, in which the investment is located. Shall is mandatory. It's not optional. It doesn't say maybe. In accordance with. So it tells the courts how is this going to be enforced. And then where with the laws of the contracting party, capitalized, must be either Switzerland or Zimbabwe, in which the investment is located. Has to be either Switzerland or Zimbabwe. And so what we are asking is just to enforce these words as they are written, which say where the award or how this award must be enforced. And it is complete. So the enforcement of this award must occur in Harare, in Zimbabwe.
I don't follow. It
Yes,
tells
sir.
you what law we use in accordance with the laws is a choice of law provision. It's explicit.
Correct, sir.
So it's telling you that it should be done in accordance with the laws of here, Zimbabwe. But I don't see anything in your brief that says that enforcing it pursuant to what, filing in U.S. District Court in D.C. is contrary to the laws of Zimbabwe for enforcing an arbitral award.
Sure. Well, I mean, in a sense, you're right that there isn't an analysis of Zimbabwean law and how that would get to the U.S., right? Neither party made that analysis, right? Instead, what we're saying is it has to be enforced in accordance with the laws of Zimbabwe, and that's just not being done. It's the laws of the United States. And so what we are arguing in the brief is just a stray interpretation of what the words say.
Well, U.S. court, if can apply international law, U.S. court can apply New York law or Zimbabwean law or any other law, right?
Now,
Done every day.
it is true that it can. Now, I think the thing with this text, and I think what you'd be referring to perhaps a New York law clause, a lot of times those are specifically found in contracts where we're looking at substantive law. In this context, it's everything, right? In accordance with the laws of the contracting party, not the substantive laws. It doesn't exclude a conflicts of laws provision, which we often see in contracts. It's everything. And there was never an application of Zimbabwean law as it applies to the enforcement of this award. Much more so in the German treaty, which says that it shall be enforced in accordance with the domestic law of the contracting party in the territory of which the investment in question is situated.
You're quoting there from 11.3, right?
Yes, sir.
The same language is in 11.2, right?
Yes, sir.
And isn't that language in 11.2 a choice of law provision, or it's talking about the source of substantive law because it's in the last sentence of 11.2, and it talks about what the arbitral tribunal is supposed to use, and it says it's supposed to base its decision on disagreement, any treaties, international law, and the domestic law of the contracting party in the territory of which the investment in question is situated.
Yes,
The
sir.
exact same.
So, well, but there is a key difference because that's what the tribunal is going to do, and this is what the court is going to do. And in the context of these kinds of
Why is it the
arbitrations,
phrase going to mean the same thing in 11.2 that it means in 11.3?
well, because in 11.2, you would get to Zimbabwean law, sort of, it's a process from the treaty to international law to Zimbabwean law, because there can be issues of Zimbabwean law that are specifically relevant to the treaty, such as the creation of a company, whether the company existed or not, whether a person is an investor because they have a passport or not. Can dual nationals bring a claim? Those things will come sort of subsidiarily after the treaty, international law, and Zimbabwean law. But when you get to enforcement, all that stuff is done, right? Especially in an ICSID case, because there's no annulment. The court's not going to come around and kill the award. All it can do is look at the award and say, well, here's how we're going to enforce it. There's a US statute to enforce this ICSID convention award, but in this context, strangely, no one knows why, there is specific language in the instrument of consent as to how it must be enforced, and that would be Zimbabwean law. So I see I'm not connecting. I guess the point is that this is an enforcement context which has a limited set of issues, as opposed to the arbitral tribunal having a much broader set of issues and a much broader mandate. And that is the key difference. Now, as far as once you look at those two laws, it's still Zimbabwean law, right? The tribunals look at Zimbabwean law, the enforcement court looks at Zimbabwean law. On that, yes, we would be in agreement. But it wouldn't be the same as the analysis the tribunal undertakes applying international law and the treaty.
So
Yes, sir.
I understood the argument in your brief to be that the language in 11.3 is not just a choice of law
Correct.
clause, but also a forum selection.
Yes, sir.
clause.
Yes, sir.
Today, it sounds like you're making a slightly different argument,
No,
that because it's a choice of law clause.
no, I'm sorry. I started with the Swiss treaty, which it doesn't have the words in the territory of. They're not there. It just says contracting party in which the investment is located. And the German treaty is the contracting party in the territory of which the investment in question is located. And so that's the difference between the two treaties. And so we're saying that the words in the territory of, they have to mean something. They're not repeating the choice of law. They're talking about where it is to be enforced. And so that's the difference
So
between
here's
the
my
two.
question about that.
Yes,
right?
sir.
If the sentence ended, shall be enforced in accordance with the domestic law of the contracting party,
Yes.
then we'd have a problem because we wouldn't know which contracting party. So the rest of the sentence answers that question. It's the contracting party in the territory of which the investment in question is situated. You need that language to make it a comprehensible choice of law provision. And what I'm having trouble understanding is why it should also be
Sure.
treated as a forum selection clause.
Well, because in the Swiss treaty, actually, you just have in which the investment is located, and you don't have in the territory of. And
Okay.
so there's a difference. What's the meaning of the difference? And that's how we get to
That's a venue question, isn't it?
as to which venue would be appropriate.
It seems to me there's two issues in each case.
Okay.
And one is common, and that is whether the district court had jurisdiction. That's dependent upon FASA. And that's dependent upon what Judge Wilkins said is the arbitration agreement. There are two arbitration agreements.
Yes, sir.
Follows that the district court had jurisdiction. Question you're arguing is whether venue was proper.
I think it's a little bit different. because of the nature of,
And the question then is whether that provision in the Swiss treaty and the same provision in the German treaty is a choice of law provision or is a venue provision. And the district court held that it was a choice of law provision in both.
yes, yes, he did, sir. And it wouldn't be a venue in this case, because we're talking about a waiver of sovereign immunity, and the waiver comes from the arbitration, the instrument that creates the consent to arbitration. And here, by selecting that it shall be enforced in Zimbabwe, then it's more than just a sort of run-of-the-mill venue provision, but rather it's saying,
Did the district court have jurisdiction to decide that this could be enforced only in Zimbabwe?
yes, sir.
Yeah, well,
Yes, sir.
that makes my point.
But I think that would come from the fact that it's a federal court that is facing an exit award that can seek, where they can seek enforcement under 22-1650A. So I mean, that's where we would see that power to come from, and then they get to the clause and say, yes or no. I am way over my time. I apologize. Any further questions?
All right, we'll give you some time on rebuttal.
Thank you, sir.
We'll hear from Mr. Paparella.
Yes, Your Honor, thank you. Chris Paparella from the Steptoe firm for the Von Pezold family appellees. And I'm here with co-counsel from Baker McKenzie, David Zaslowski, who represents the Border Company and Border Timbers and Hangani, the other appellees here. He's with his partner, Graham Kernog, and I'm with my colleagues, Michael Barrett, Justin Van Asher, and Jenny Askew. Mr. Zaslowski and I have divided up the 10 minutes you gave us, 5 minutes apiece. I'm going to cover the arbitration exception in the FSIA, and Mr. Zaslowski will cover the waiver exception if we get to that. I'll keep my remarks brief. It's the submission of both sets of appellees that the provisions that Zimbabwe relies on in its investment treaties with Germany and Switzerland are choice of law provisions. The phrase "in the territory" is answering one question and one question only: which territory's law applies? And this is highlighted by the very similar language that's contained in Germany's investment treaty with India, which Zimbabwe quotes and relies on at page 3 of its brief.
And the Swiss treaty doesn't have that language, does it?
The Swiss treaty's language is somewhat different than the German treaty. The Swiss treaty's language says the laws of the contracting party in which the investment in question is located. The German treaty says the domestic law of the contracting party in the territory of which the investment in question is located. And the Indian-Germany treaty says in accordance with the national laws of the contracting party where the investment has been made. So each of the treaties uses a slightly different verbiage, but all three verbiages seek to answer the same question. And the question is not where, but whose law? Whose law? And they get, because you can say the same thing in different ways, and that's all they've done here. Our submission is that once you satisfy yourselves that those provisions are choice of law provisions, the next error, your decision in next error a few weeks ago applies here. And next error lays out a very simple test. Is there an arbitration agreement? And that first question has two levels. Do you have it here? You have two investment treaties. Do those treaties contain an agreement between two countries to offer arbitration to each other's nationals? And the answer here is yes. Both treaties contain an offer to arbitration. Was that offer accepted by the nationals?
Does the Republic of Zimbabwe even contest that point?
They don't contest that point, Your Honor. They don't contest that point. They don't contest that there are arbitration awards. They don't contest that those were ICSID awards. These people arbitrated for 8 years under ICSID. They had an opportunity to try and nullify the awards. And lastly, they don't contest that the awards, there's a treaty signed by the United States, Zimbabwe, Germany, and Switzerland that governs these awards, that provides for enforcement. That's the ICSID treaty. They don't contest that. It's on page 1 of the reply brief.
What is the United States connection with this case?
The United States connection with this case is that the appellees are seeking to enforce in the United States. And the arbitration was held here. It was held at at ICSID's offices in Washington.
Zimbabwe seems to contest whether it was really held in the United States because the territory of the World Bank is not in the United States. Is that the theory?
The World Bank is not the Vatican, Your Honor. The World Bank is located in the United States. I know, I'm sorry. I don't mean to be sarcastic. That's their argument. We dispute that argument, Your Honor. That there's no dispute between the parties that on the agreement of the parties, and they could have agreed to hold the hearing someplace else. ICSID allows them to do that. They agreed to hold the hearings and did hold the hearings right here in Washington, D.C. in the United States of America. And so that's the connection between the United States and the ICSID convention and this case.
But the World Bank is it's like an embassy, right? As far as application of international law?
In terms of taxation, yes. I don't know that it's an embassy, and they don't argue that it is.
Employees are not taxed by the federal government, World Bank employees, no matter what their citizenship is. But there's questions. Matter of fact, we've had cases dealing with what United States laws, for example, Title VII and discrimination apply to the World Bank. So it's a mixed question.
I understand that, but even if the court were to accept Zimbabwe's argument that holding an arbitration at the World Bank in Washington did not involve holding an arbitration in America, confirmation under the foreign arbitration exception of the Foreign Sovereign Immunities Act would still be proper,
Right.
Because the United States has adopted as a party to the ICSID Convention. It has agreed under the ICSID Convention to enforce ICSID awards from other ICSID countries. Zimbabwe is an ICSID country, Germany is, and Switzerland is, and so enforcement is proper here.
So your contention would be that even if the arbitration had occurred, let's just say in Zimbabwe physically, enforcement would still be proper here.
Absolutely, Your Honor. You can
Because there's nothing in the FSIA that requires there to be some sort of a connection to the U.S. of the dispute or the arbitration or anything else for there to be subject matter jurisdiction of a U.S. district court.
That's correct. Nothing in the FSIA, in the FSIA, and in particular in the arbitration exception in the FSIA, requires that the arbitration itself have a connection with the United States of America. In fact, although this did not come up on appeal, but below, Zimbabwe raised the forum nonconvenience argument, and there's a long line of cases that holds that this court and the district courts in D.C. have held that forum nonconvenience is not an appropriate inquiry when you're seeking to enforce an arbitration award from another country under one of the treaties that the United States is party to that covers arbitration awards.
All right. There are no other questions. We'll hear from your colleague, Mr. Wilkins.
Thank you, Your Honor.
May it please the court, David Zaslowski from Baker McKenzie, and as noted, I'll be addressing the waiver exception. And I recognize from Judge Wilkins from what you said that based on recent jurisprudence from this court, you may not get there if you think the arbitration exception applies, and we certainly think it does. But if you do get to the waiver exception, all of the cases before you that have discussed the issue of whether the implicit waiver exception of the FSIA applies when parties seek to enforce an ICSID award against an ICSID signatory, they've all held that the implicit waiver exception applies. Zimbabwe has not put before you one case that goes the other way.
We've never held that in a reported decision, right?
You've never held that in the reported decision. In Tatneft, and Judge Wilkins and Judge Randolph, we're on that panel. I mean, you've held it in an unpublished opinion. You said that the Second Circuit, you agreed with what the Second Circuit said, and that, a sovereign, by signing the New York Convention, waives its immunity from arbitration enforcement actions in other signatory states. And that was in an unpublished opinion. And in Creighton, you opined in dicta that the Second Circuit was correct when it held that foreign sovereigns waive sovereign immunity. So you've done everything other than, as you said as the court said in Nextera, everything other than formally adopt it. If you get to the waiver exception here for whatever reason, nothing that Zimbabwe has said should lead you to change your reasoning in Creighton or in Tatneft, or to disagree with the Second Circuit's reasoning in Blue Ridge or in Mobile Cerro. And there's also the recent TIG decision in which this court said there are three scenarios, that was about 7 weeks ago, there are three scenarios in which there is an implicit waiver by a foreign sovereign. One of them is arbitrating in the United States. And getting to the issue we just talked about, our position is there absolutely was an arbitration here in the United States. And so you could affirm the waiver exception argument based on the TIG grounds without getting to this other issue that the court has been hesitant to get to. But if you do get there, if you do get to the issue of the interaction between the arbitration conventions and the explicit waiver, the implicit waiver exception, I said there's no reason to change from what you said. The primary argument that they make in their papers is to rely on the amicus brief in the PIND case. And in that case, the issue that the court asked DOJ to opine on was whether the United States impliedly waived its immunity in courts of other New York Convention countries. That's the question that was asked. And the government said, we're not answering that question. They specifically declined to answer that question. What they did then say, their interpretation of the FSIA, that's not entitled to any special deference. That's just an interpretation of a statute, not an interpretation of a treaty. But even if you do look at what they said about interpreting the FSIA, all they said on pages 12 to 13 of that brief is that there is a way to interpret the waiver exception together with the arbitration exceptions. There's a way to interpret it that the two are exclusive. But they also noted that your decision in Tatneft rejected that interpretation, that the two of those were exclusive. So there is nothing before this court that should lead you to, again, as I said before, any other conclusion than what you laid the groundwork for in Creighton and in Tatneft, and that the Second Circuit has decided. And unless there are any questions, I will leave it there.
Just very briefly, am I right that a predicate for every version of your implied waiver argument is that there is an arbitration agreement?
Is that there is an arbitration agreement.
Is an arbitration agreement, an award, and a treaty under which it can be enforced? I guess I'm trying to understand why our court would ever reach this question, because don't you always already have to win the arbitration exception issue? I admit this is a little academic, but
well, it is a little academic. I haven't thought about, is there an example where one would apply and not, but I do note that in Tatneft, I mean, this court said, and I'm quoting, the waiver exception requires a foreign sovereign to give up its immunity defense intentionally, whereas the arbitration exception does not. So while the exceptions partially overlap, each contains its own unique elements. So this court did consider it in Tatneft. It did say that. I cannot stand here right now, give you an example where one would apply and the other would not.
All right, thank you. Mr. Smith, we'll give you 3 minutes on.
Thank you, sir. On the arbitration exception, we heard that it's about whose law applies. There was an argument that Zimbabwe law was applied, which would be a pretty key distinction. That's what actually happened. We heard arguments about whether the arbitration was, quote unquote, held here. Just to quick distinction. This isn't like Crystal X, which this court handled. That was an additional facility case. The place of arbitration was Washington, D.C. This is an ICSID case, and this court cannot compel arbitration before the ICSID convention. That's mine versus Guinea. I mean, it is a different species. Whenever you go to ICSID, you renounce other remedies in other courts. It is a different kind of arbitration. We've cited authority for that from the scholarly authority, and there is no contradiction. There was a question about the FSIA and a link to the United States. That's not this case. It can arise in different kinds of cases. We have another case before the DC Circuit on that issue, so I don't want to just say it's okay. The FSIA doesn't have to have a connection to the United States, but it is out there in different kinds of cases. And then the final thing, Judge Garcia, I just wanted to touch on, what was suggested to be an academic argument. Perhaps that as soon as you have an arbitration agreement, an award, and a treaty, that's it. In NextEra, there is that discussion that, well, it's just scope. And once there's scope, that's a merits decision. But that's scope of what is arbitrable, which is a different question than scope as to where it can be enforced and how it should be enforced. And that's this case. There's not going to be a lot of cases like this. There aren't that many trees out there that are like this. But these specific words need to be enforced as they were negotiated by the parties. And that's why we ask that this court reverse and with instructions to dismiss. If there are no further questions, then I will end early.
Thank you. Take the matter under advisement.
Thank you, sir.
Case number 23-5183. Crowley Government Services, Inc. Appellants versus General Services Administration and Robin Carnahan in her official capacity as Administrator of the General Services Administration. Mr. Boland for the appellants, Mr. Hazel for the appellees.
Morning, Mr. Boland.
Good morning, Your Honor. James Boland for the appellant, Crowley Government Services. May it please the court. This case is not about whether Crowley will be audited. Crowley welcomes an audit under this contract and always has. The question is about who will conduct the audit under what legal authority. So we've discussed
That question is not presented either.
I beg your pardon, Your Honor?
I said that question is not presented either.
I understand it was not framed that way.
Because of the letter.
I'm not sure which
You
letter.
said who is going to do the audits under this contract is the issue. But that issue is not presented in light of GSA's letter. It says we're not going to audit you anymore under this contract. So why isn't this case moot?
Your Honor, the case is not moot because there is a substantial risk that these audits would resume.
We'll resume. So your point is GSA may go back on its promise not to audit?
It's not a promise. It's a letter stating a position at one point during
There's
during
an
the
opinion
litigation.
by Judge Scalia when he was a judge on this court talking about whether when a representation is made by the federal government, whether they have to be enjoined. And he said no. That the federal government is such that we can trust it when it says something that it's going to abide by it. And if there's a problem there, then why not have the district court just embody the letter as a consent decree, which would then give you all the relief that you could possibly ask for in this appeal?
Your Honor, I don't know that GSA would accept that. I don't know
Well, we'll
that.
see. We'll ask them. Why wouldn't they accept it if they've written letters making that representation to the district court?
Yeah, and again,
I don't think they even need it in light of the Judge Scalia's opinion in Espinoza, I think it was.
So there's a few comments on the mootness. So in our view, given the lengthy litigation history, this is not a situation where GSA is changing its policy.
Before you go any further, your complaint does not seek any retroactive relief, correct? You're not seeking money damages.
Correct.
Or anything like that.
That's correct, Your Honor.
Right.
Right.
Okay.
Yeah, we're
Any perspective?
it's prospective relief under the contract, and this audit authority. This is an important authority for GSA's Transportation Audit Division. They have taken this view that they have the authority to audit contracts. They intend to audit the next contract, and as by way of reference, Crowley was recently awarded the DFT.
Let's suppose we agree with all of that, but taking Judge Randolph's point, if we believe the case law says that GSA would be bound by the representation of their letter for the duration of this contract, and your friend on the other side represents to us that they consider themselves bound by that, and all you're seeking is prospective relief with respect to this contract, not other future contracts or other contracts. What is there for us to do?
Well, Your Honor, I mean, one of the concerns is that this harm is not ending. Crowley was awarded the DFTS2 contract. This is continuing on for many, many years. The lower court's decision, as I understand it, is binding on Crowley. It has collateral estoppel effect. And the problem is we're going to be right back at this in a matter of months when the next contract transitions and GSA resumes. GSA has made very...
If the case is moot, we vacate the district court's opinion decision.
If the court intends to vacate the district court's decision, we would not object to that.
What
if
has
GSA
happened with the proposed legislation that GSA put before Congress in March?
As far as I'm aware, the Congress has not taken that up. It has not been enacted or passed, but
And no committee hearings?
not to my knowledge. And they've tried twice on that.
What the legislation did, it was to prevent this conflict. And whose side won in the legislative proposal?
So the legislative proposal was actually came from the Department of Defense, and it was it sort of took GSA's view on this, and the proposed legislation would essentially eliminate or carve out the Transportation Act from the CDA and basically allow GSA to audit a FAR-based contract. I mean, the very issue that it's directly in response to this litigation. Now, it's an interesting fact pattern here because the Transportation Command, the Department of Defense, has been on Crowley's side throughout this. That was one of the areas where we did obtain relief in the lower court. I think for the court's understanding, what really is motivating this is the source of money. When DoD audits contracts, that audits are paid by appropriations for DoD. But if they can sneak in an audit through GSA, GSA pays for the audits by money it takes from the contractor. So that's why this fight is really here. And I think I'm presuming, but my understanding is that Transcom, the Department of Defense, is proposing this legislation because they can have GSA audit under a different legal authority and they don't have to pay for it. So, in light of this discussion, I'm pleased to turn to any of the substance, but I don't want to if the court would prefer that we.
I guess what I'm trying to understand is, that if I look back at how the district court put it in its opinion, is that the district court said, well, the case boils down to two questions. And is GSA authorized to audit Crowley's contract with US Transcom. And then if so, but audit determinations are disputed by Crowley, what statutory dispute resolution scheme applies? Well, if the district court is correct, let's start there. Is the district court correct that that's really the framing, that those are really the two issues presented by your complaint for declaratory injunctive relief?
I wouldn't necessarily agree with the framing as to which dispute process applies, although there's overlap. I mean, the thrust of our action is whether GSA has the legal authority to conduct the audits. And we've argued that because these two statutes are comprehensive in the areas that they're intended to cover, ICA regulated carriers and government contractors, those are sort of the two buckets. When the audit authority under 3726B, that authority applies to that statute and the subject of that statute, which are ICA regulated carriers. And so what the court basically did was took out subsection B, the audit authority, and said, I'm not going to address the rest of the statute, but I think because B is broad, that allows us to audit government contractors. And what we've said is, because both statutes are comprehensive, and we've looked at the two Federal Circuit cases that talk about how the dispute processes are in conflict, but we're not really dealing with a dispute here. We're dealing with on this question, the audit authority. We're saying that because the audit authority is part of that comprehensive system, you can't pull out the audit authority. If the disputes processes are mutually exclusive, so is everything else.
I understand that's your legal argument, but I guess, just as an old district court judge here, former district court judge, getting down to brass tacks, you've asked for relief. And if you get the relief that GSA prospectively cannot and will not audit this contract anymore, then there's no need to answer any further questions about how we resolve any dispute with respect to an audit you disagree with, because there won't be any such audits, right? So really, ultimately, if you prevail on that issue, if I were a district court judge, I don't see why I would have any reason to decide anything else. If the district court judge had said GSA had no authority to perform these audits, would the district court have any reason to rule on anything else in your case?
No, Your Honor.
So if there's a letter that is binding, and there was even a Rule 68 offer of judgment that was tendered, right?
That's right.
Such that you have the equivalent, really, of a judgment, at least for the purposes of this case, with something that's enforceable with respect to this case, that they're not going to perform any more audits. What's left? Why are we here? What do you want us to do?
Yeah, well, Your Honor, I mean, we would concede if the decision below is vacated, then and GSA would reach that agreement, then we would concede that it's moot. But our understanding is that GSA is not willing to give up this argument for the DFTS program, and I think that's one of our concerns, that we're about to begin the next contract, and this is it's an issue that's not going to go away. We're concerned that we're going to be right back out here again and have to essentially relitigate the same issues again.
So the letter that you have right now sort of specifically says they won't audit you under this current contract. Doesn't speak to the next contract.
Correct.
That's on the horizon.
Correct. And GSA 100% is planning to audit the next contract. And so, and we've had those discussions, and my understanding is they are not willing to
How do we know that they're going to audit the next one?
It's language to that effect has been included in the next contract, and so, which this one does not have. In fact, Transcom changed the contract to deem Crowley a carrier on the next contract in response to this argument here. I mean, through discussions with GSA, that's something that we've offered and proposed, but the government has not accepted that position.
I mean, has the next contract been signed?
Yes, it has. In July.
All right, so moving to the merits then, why don't you move to the merits? Explain to me, I guess, the district court and the government's argument, I think, on authority kind of boils down to the language of 3726B is new, was added in 1998, correct?
That's right.
And by saying transportation bills there, but not saying bills from a carrier or freight forwarder, like it says in A1, and like it says in other parts of 3726, that omission is significant. And so transportation bill doesn't have to mean always that it's from a carrier or freight forwarder. Why isn't that a pretty straightforward textual proper reading statute?
So Your Honor, I think I would begin by just referencing addendum page 72, which is the 1998 legislative history. It is, in our view, it's crystal clear that when Congress added subsection B, inserted that and broke up the existing paragraphs in Transportation Act, there was absolutely no intention or even understanding, not a whisper, that they were expanding the audit authority outside of ICA regulated carriers. The description on page 72 shows, in the legislative history, talks about transportation bills. Transportation post-payment audits are a historical legacy of a regulated transportation market. Crowley's not regulated by the ICA. Congress understood that when they were adding this post-payment audit, they were simply, what they were doing was, in fact, the Act, 1998 Act, was intended to mandate prepayment audits because they talk about how post-payment audits are ineffective. They were essentially spending a dollar to get a dollar, whereas prepayment audits were much more cost effective. So the whole purpose of the 1998 amendment was to stop and reduce GSA's post-payment audits, shift it to prepayment audits. There's not a hint anywhere in the legislative history that's what Congress intended. And as we've discussed, it's not just a plain text reading of B. The statute doesn't define transportation bill, but it does talk about bills throughout. And when you read it in context, you read that one audit line in context, it's very clear that they're talking about transportation, that the transportation bills are those presented by carriers to the government for payment. No carrier under this contract submits a bill to the government. There's no presentation of a bill. The government doesn't pay any carriers. That's entirely, Crowley negotiates rates with carriers. They pay them. Crowley has separate rates. The payment under the contract is a traditional government contract where the rates were set by competition. The ICA has nothing to do with this contract. And so
You've said a few times that the ICA doesn't regulate Crowley if it's a broker, treated as a broker. I thought there were at least some requirements that the ICA imposes on brokers, including, registration and, notification requirements, things like that.
Yes, Your Honor. Just to be clear, we've analogized Crowley is like a broker in its role, but we don't actually argue that they are a broker under the ICA. We're saying that under this FAR-based contract, they're essentially acting what would be equivalent to a broker under the ICA, where they are not involved in the physical move. They're not taking physical possession of the freight. This is a contract where Crowley is the coordinator for DoD. Crowley selects carriers, hires them. I mean, they're running the entire DoD freight transportation process. So that involves a massive amount, millions of dollars of software development. There's labor teams involved. This looks like a government contract. Within that umbrella, you have them, Crowley, actually engaging subcontracting to carriers. But Crowley
also said earlier the dispute is about who's going to conduct the audit, and I was just curious. I couldn't find in the brief an explanation of what other government entity, if any, and under what authority would audit a contract like this in your view?
The Defense Contract Audit Agency, DCAA, is the Defense Department's primary audit agency. They exist solely to audit contracts like this. And they audited the predecessor contract to this contract before GSA decided to start taking over. And so the government, that was sort of my point, that there's no one here is trying to avoid the audits. But the issue is when DCAA audits a government contract, the auditors give a recommendation to the contracting officer. They respect the CDA authority, and then the contracting officer can decide whether or not they agree with the audit determination and issue a claim. That's how every government contract operates. That's how this one should operate. But the problem is when GSA, under this other statute, which doesn't apply here, when they audit, they make binding determinations, and then under their process, they then proceed to collections. And there's an inherent conflict. And I think one of our concerns and one of the reasons why we're here, even though we prevailed on the issue of that the Transcom's contracting officer's final decisions are binding, the court's analysis of getting there was incomplete, and it doesn't work. You cannot have a system where GSA can audit a contract, as they did here, declare millions of dollars in overcharges, 10,000 plus notices in a single electronic transmission, and then channel it and then divert to the CDA, and because we don't even know if there's a dispute yet with the procuring agency. We have to treat it like a dispute, submit a claim under the CDA. The contracting officer has 60 days at least to decide the claim. Meanwhile, during those 60 days, we could lose millions of dollars with no interest, which were guaranteed under the CDA. And if we get a favorable contracting officer's decision, the lower court agree with us that it would bind GSA. That's great, but it doesn't deal with the first 60 days. It doesn't deal with the lack of interest. The court also did not consider what happens if we submit a claim to the CO and they agree with GSA. What happens there? The court suggested we go back to GSA under C1, the shall adjudicate language, but that's impossible because the courts under the CDA, the CO's decisions are binding. So that would be futile. We'd go to GSA, they'd be bound by the contracting officer's final decision. Under the CDA, we're entitled to appeal to the Board of Contract Appeals and the Court of Federal Claims and Federal Circuit. The district court's decision below doesn't address that. Essentially, the judge would shift it back to the GSA, which again doesn't make sense and effectively would be repealing the CDA. So,
can you help me understand 3726I? If you can get that language in front of you, in particular I1. It says that a carrier or freight forwarder may request the administrator of general services to review the action of the administrator if the request is received not later than 6 months after the administrator acts, et cetera, et cetera. I don't understand why would you request the administrator to review the administrator's own action? What administrator are they referring to there?
My understanding of that is essentially the statutory basis for the appeal process. So if like the Transportation Audit Division, which is GSA, and I think that's why they refer to it as the administrator in that context. If a GSA office adjudicates the claim against Crowley, then the appeal would be to go higher. So I think I is the appeal right under the statute, under GSA's process.
So when it says to review the action of the administrator, they don't mean the administrator of general services. They just mean the contract administrator.
My understanding is that they're referring to GSA's Transportation Audit Division and that authority who would review.
Okay, so not the contract administrator, but someone within GSA, but not the administrator of GSA, even though it uses the administrator capitalized, which would seem to infer they're talking about the head of the agency or the administrator of the agency.
That's right, Your Honor.
I guess I'm just trying to make sure I understand your position, okay, so let's suppose we believe that 3726 should be interpreted the way that you say, in that GSA only has the authority to audit carriers, bills of carriers. Why aren't you a carrier?
Because under the contract, Crowley does not hold itself out as the entity moving, physically moving the freight. That's an important distinction. The contract refers to the carriers as subcontractors. There's a clear distinction between the two. It's in writing, and we think under I think it was the 11th Circuit's Essex decision, our role, Crowley's role is in writing. So the public does not think that Crowley is the carrier under DFTS. Everyone knows it's the actual carrier, common carriers that are doing the movement. Crowley is just the prime government contractor who's coordinating this all for DoD. But so we think the court can determine that we're not a carrier on that basis alone. But at a minimum, it's something that the lower court did not decide. Because the court determined that that was not relevant. But we think at a minimum, that's something that should be examined for further consideration below.
Just to go back to the main statutory interpretation question, I think one outcome of your reading would be that for this category of entities called brokers, whether you are one or not, your reading would mean GSA cannot audit them, even though they are, performing some role in carrying out transportation contracts for the government. And I'm just wondering if you have an explanation of why Congress would have set up the system that way, where GSA can only audit carrier contracts and not broker contracts.
So I'm not sure if I can give you a definitive answer, but my understanding is, the carriers are the ones billing the government. And so, and that's part of why, that goes sort of our interpretation of the statute. The carrier is, the carrier presents a bill to the government. They're the one, and under
Crowley doesn't present bills to the government.
We don't present carrier bills. We don't. The government's not paying the carrier under this contract.
Right.
Crowley does, but it's not a cost reimbursement contract. So the government pays Crowley invoices under our government contract. Those invoices include the services that were performed by Crowley and the subcontractors, but those rates they're not tariffs. They're not ICA regulated carrier rates. They're the three circumstances. That's one of the reasons why we think the court's analysis would sort of lead to an irrational result. The whole purpose of these audits is to determine that common carriers are not billing the government more than they're allowed to, which doesn't make any sense in a contract like this, because the government has no privity with carriers under this contract. No carrier is billing the government anything. They're billing Crowley. It doesn't matter what they're billing Crowley, because Crowley has set rates, set prices that Crowley proposed in a competitive acquisition 6-7 years ago. Those rates, we're entitled to contract rates or contract price. And Transcom is certainly capable of determining whether we're billing correctly and whether our services are performed correctly. That's one reason why we disagree with the government's argument that GSA is needed for expertise. No one needs GSA's expertise here. In fact, the problem with GSA is that they don't understand what's actually going on in this contract. It's one of the reasons why Transcom below told GSA to stop issuing these NOCs, because they don't understand the realities of performance. But I guess to Your Honor, to answer the question, I don't know that the brokers would be billing the government, and that you'd have that same issue where I don't know how the broker would be paid, but you don't have the same issue where you would have a carrier with an ICA regulated rates, whatever they're allowed to bill. That's all GSA is doing. They're just making sure that common carriers are not overbilling the government. That's the whole purpose of 3726. In fact, you go back to the 1940 statute, the original statute, it even refers to upon presentation of bills by the carriers, subject to the ICA. That was the original purpose of this statute.
I guess I just don't understand why they couldn't be auditing and checking whether the broker is abiding by whatever rates they secured in the FAR process. Doesn't seem nonsensical to me. Sure, it might be different. Sounds fundamentally the same. You're checking whether
Yeah.
the contractor is submitting a bill
Yeah,
that accords with, if they've actually provided the services they promised to.
right. I don't know if I can understand what, why Congress did not, but they had the opportunity. They added freight forwarders 30, 40 years ago. They did not add brokers. So at least we know that was Congress's intent.
All right, unless there's other questions, we'll give you some time on rebuttal. We'll hear from Mr. Hazel.
All right, thank you.
Good morning, Your Honors. May it please the court, Stephen Hazel for the government. Thought I'd start by clarifying 3 points. One about the letter and then 2 on the merits. The letter states that GSA would not continue auditing this contract, which, as counsel pointed out, the time has almost run. GSA stands by the letter. The letter does not state that GSA would not audit future contracts, including this, the second round of this contract, which has been awarded, or at least preliminarily awarded to Crowley. It's a multi-billion-dollar government transportation contract. It's important both to GSA and to DOD that GSA's auditors be available to audit that contract. So that's sort of the state of play with the letter.
I am having difficulty understanding it. Could you repeat that?
Of course, Your Honor. The letter states, and we stand by, that GSA will not audit DFTS, Defense Freight Transportation Services contract. There's a second round of that contract called the DFTS-2 that has been awarded to Crowley, and it's important to the
But
government.
that's not the subject of the lawsuit, is it?
That's right, Your Honor.
Okay, so the only contracts that are the subject of the lawsuit, GSA has represented that it will not audit.
That's correct, Your Honor.
And it refunded, what, how many millions of dollars to Crowley?
It was north of $20 million, Your Honor. That's correct.
So on behalf of GSA, do you have any objection to memorializing that letter in the form of a consent decree?
So, Your Honor, I'd have to talk to GSA about that. I mean,
What
certainly.
possible objection could you have?
So, Your Honor, as I said, we stand by the letter. We haven't contested the district court's mootness ruling. Neither side has briefed mootness here. So I think if that's something the court is going to address, supplemental briefs or letters may be appropriate. As I said.
The letter came in before the district court's decision, correct?
That's correct, Your Honor. Again, we don't contest the mootness ruling. We haven't addressed it.
And your GSA stands by it, which means they're going to adhere to it.
That's right, Your Honor. GSA has issued the letter. We stand by it. I'm not aware of, any reason or any plan of the agency to retract it.
When do those contracts expire?
I'm not sure of the exact date, Your Honor. I think we're approaching the point when it will transition from the DFTS-1 to the DFTS-2 contract, but I believe Crowley's contract counsel would have the exact date.
You don't know when they expire? Is that what you're saying?
I'm not sure of the exact date when it switches from the first round to the second.
Close?
I believe so, Your Honor.
How close?
Again, Crowley's counsel will have the exact
Well,
dates
I'd like
for
to
it.
know that because that's another reason why this case might be moot. I mean, if the contracts expire, then that would be an additional reason why the case is moot. Because they're only seeking prospective relief.
So
let me ask you, when do these contracts expire?
Contract's still ongoing. The new award is under protest. And so I think that the current contract will run at least 4 to 6 more months. But the new contract has been awarded.
Right.
Transition.
Well, that's what I'm asking.
So, Your Honors, I do want to make sure I discuss the merits. And I think we have 2 arguments here.
One second on mootness. So the opposing counsel also mentioned that there might be different terms in this future contract. So if the idea is this second contract is going to keep this case alive somehow, there might be material differences if that if they've agreed in that contract to be treated as a carrier, for example. Seems even if any future contract could keep the case about this contract alive, it might not be that one. I mean, how do we think about that?
So, Your Honor, I mean, we obviously haven't provided a comprehensive comparison of these two contracts. I mean, what I would say is the contract that the court has before it, the first round DFDS contract, I think makes sort of everything clear that needs to be clear for the court to resolve this case. With respect to the carrier issue in particular, the question is, do you have legal responsibility for the shipment? You can move it yourself. You can choose to outsource that to someone else. But if you're legally responsible, if the shipment is damaged or lost, then you're a carrier. And this contract makes that clear. There's a section, I believe it's at JA 107, that talks about contractor liability. And it spells out explicitly that if the shipments are lost or damaged, Crowley is responsible. And then it goes on to make explicit that that is true regardless whether Crowley self-performs or whether it chooses to outsource. So this legal question.
Where does this legal responsibility test, though, how does that comport with definition of carrier in the statute?
Yes, Your Honor. So this is that legal responsibility test, which comes from Essex. That's how circuits, that's how district courts, that's our understanding of how every court to look at that statutory language has interpreted those definitions as part of the Transportation Act. As we've emphasized, the definition of a carrier is broad. It includes not just performing the movement yourself, but arranging for someone else to do that.
Well, if that were the case, then every broker would be a carrier. But that clearly doesn't make sense, right? Because the broker in 13102(2), definition of broker, says that a broker is someone other than a carrier, right? So Congress intended for those to be two different things. And it says that a broker also arranges for transportation by motor carrier for compensation.
That's right, Your Honor. And I think as you read that, you actually highlighted the key language, which is other than a carrier. So Congress recognized that when these definitions overlap, if you fall in the carrier definition, then you're not a broker, right? If the sort of Venn diagram overlaps, then you're a carrier, not a broker. And that's the case for Crowley here. We've cited Essex, we've cited a number of circuit court decisions. They've, in their reply, pointed to a couple district courts. Those cases say the same thing that we do, which is you don't need to actually move the cargo. It's enough if you're legally responsible for it. Under that definition, given the language of the contract, which we've just discussed, it's clear that Crowley is a carrier as a matter of law, and the court can affirm on that basis.
So when will a broker not be a carrier?
So, Your Honor, I think
when they're arranging for transportation with a motor carrier.
So, Your Honor, in a situation where the broker is not taking on liability for the shipments, if they're lost or damaged, you could imagine a different version of this contract that made clear that Crowley would not be liable for these shipments.
But that's why I asked you at the beginning, what does legal liability have to do with the text of the statute? I don't see that anywhere in the text.
Your Honor, this is the way that courts have understood the statute, and it's the place that this legal responsibility test comes from. My understanding, and I think Essex's understanding as well, is in the common law of bailment. So courts were reading the statute in light of those common law of bailment principles, which recognize that when someone is hired to transport something, they can't get out of their liability by outsourcing it to someone else. I think that's the principled basis underlying all of these decisions. And I'll just note that the contract itself adopts a very similar definition of what a carrier and a broker is. I believe that's at JA 177. It has a broker definition that's the same as the Department of Transportation definition that Essex relied on. So, those are the authorities that we've pointed to. Crowley really hasn't pointed to any contrary authority on the carrier broker question. I do also want to address the district court's ruling and our alternative argument, which is that regardless of whether Crowley is a broker or a carrier, these are transportation bills under 3726B. Judge Wilkins, I think you asked my friend, isn't the plain language of subsection B, doesn't that indicate that these are transportation bills regardless what kind of provider you are? I think the statutory definition of transportation is clear. It's not limited to carriers. It covers all services related to the movement of people or property. Crowley doesn't have an answer to that definition. The district court relied on it. We've relied on it in our briefs. Crowley just hasn't addressed that part of the statute. Instead, they focused on legislative history. We think that history supports us. This provision used to authorize GSA to audit carriers. It did that expressly. Congress later amended it to say you can audit carriers and freight forwarders. And then in this 1998 change, Congress removed that language and instead said all transportation bills. Our reading and the district court's reading gives effect to that 1998 shift. Crowley's reading does not. So there are these significant problems with Crowley's reading under the text, under the structure, and under the legislative history as well.
The definition of transportation certainly helps you, but the term bill is undefined. And their argument is as a matter of structure and context that the statute is always using the word bill to refer to a bill from a carrier. And that in fact, it would be very odd to have a statute that has subsections, A, C, D, E, F, all about carrier bills, and subsection B sort of sticking out like a sore thumb and talking about something else entirely. And I guess what's the response to that contextual argument about what the word bill means?
So, Your Honor, I think that aspect of Crowley's argument is really the opposite of how this court normally interprets statutes. I mean, when Congress uses limiting language in one provision, but not in others, usually this court would give effect to that congressional choice. And just to take a step back and explain how we think about how all of these provisions fit together, Congress created a system where the government's transportation audit specialist has broad audit authority, but less expansive authority over non-audit activities, things like dispute resolution. You can see that in the statute's text and structure, right? Congress, when it wanted to limit something like dispute resolution to carriers or freight forwarders, it said that, but it didn't do that in subsection B, the provision about GSA's audit authority. And that's
the problem with, I take your point that, okay, yeah, in a sense, when we see language that's missing from a provision that's added, that's significant. But we also are supposed to look at the whole, context of the statute and have it make sense. And this lawsuit shows why your interpretation doesn't make sense with respect to the fact that you have GSA performing an audit and you have the contracting officer disagreeing with the audit, and nobody knows how that's supposed to be resolved because it doesn't fit within the scheme of 3726, and it's nonsensical. So why isn't the easiest thing and the most sensible thing for us to conclude kind of the best reading and most reasonable reading of the statute is that this sort of audit just is outside the scope of 3726B?
So, Your Honor, a couple responses to that. I mean, first, there's nothing surprising or unreasonable about what Congress did here. It makes sense for Congress to say, look, we want our specialist transportation auditor to have this broad authority, but with respect to resolving disputes, there's always a contracting agency, there's always a contract involved, so there's always going to be some other agency that's in a position to resolve the dispute.
So
it doesn't always need to be.
How is this supposed to get resolved?
This particular dispute, Your Honor, I think because of the letter that we discussed earlier and because of.
Now, let's suppose the letter didn't exist and we've got this controversy and it's not going away. How is this going to get resolved? How under this statutory scheme does this get resolved?
So, Your Honor, we haven't challenged the district court's ruling on the dispute resolution issue, which was in Crowley's favor, as I think that they acknowledged. So the court recognized that for these audits, it would be Crowley's preferred resolution process, which is the Contract Disputes Act. So going through the contracting officer and eventually going to the Court of Federal Claims if the case gets that far.
And how do they get relief in the Court of Federal Claims against GSA?
So, Your Honor, my understanding is that Court of Federal Claims cases are always against the United States. They're not against a particular agency. And so this idea that, GSA, wouldn't be subject to a Court of Federal Claims ruling, I'm not sure that there's a basis for that aspect of Crowley's argument. I think under either of these dispute resolution processes, whether it's the Transportation Act or whether it's the Contract Disputes Act, at the end, you get to go to the Court of Federal Claims and get a hearing there. I did just want to mention.
What about the fact that you can't get interest?
So, Your Honor, I think whether or not you get interest is perhaps more complicated than Crowley lets on, both whether you are always going to get interest under the Contract Disputes Act, whether you get it under the Transportation Act, I believe depends on a separate statute called the Prompt Payment Act, which has different conditions. I think the key point here is whether or not Crowley gets interest. I mean, that can't be what drives the court's decision about how these statutes interact, especially because the case as it comes to this court is about the audit authority issue and not the dispute resolution issue. We didn't cross appeal on that. That's not something the court needs to resolve in this case.
Well, we do have to resolve whether your proffered interpretation makes sense in light of the entire statutory scheme, both the Transportation Act and the Contract Disputes Act, right?
That's
I
correct.
went back and I looked at a lot of treatises, and they all seem to say that the Contract Disputes Act scheme is separate than the Transportation Act scheme. Following basically the reasoning of Dalton, right, from the Federal Circuit and the Comptroller General decision that it cites, or the case that, or other cases cites that are cited in Dalton. So what about that?
So, Your Honor, just to be clear about how the CDA and the Transportation Act fit together with respect to this case, the CDA, as Your Honor points out and as the name suggests, it's about disputes. It's not about audits. It's not about reviews, inspections. And so as the district court recognized, there's just no conflict between the part of the Transportation Act that's at issue here and the Contract Disputes Act. One allows GSA to perform audits. One sets out a dispute resolution process that might apply after one of those audits are complete. So, in our view, the Federal Circuit cases that Your Honor is referring to support GSA's reading and the district court's reading as well.
I thought there were no further disputes between Crowley and the GSA from the date of the letter, because GSA agreed to refund all the charges that were posted by this notice of overcharge. Is that right?
That's right, Your Honor. I had understood the question to be sort of asking more generally how these statutory schemes fit together rather than with respect to the particular.
Well, there is one dispute, isn't there? There's $11.8 million in the Court of Claims.
That's right, Your Honor. Crowley has brought a separate Court of Federal Claims case where that money is at issue, and that case has been stayed pending this one. If I know I'm way over time, if I could just.
I have
go ahead.
a question. Can you just clearly lay out what GSA thinks its authority is with respect to this audit? So one way to tee it up might be in their reply brief, Crowley says, if all we're talking about here is an advisory audit that I guess the agency could take and run with as it pleases or not, then they would have no problem with that. Is that all you're saying GSA can do?
So no, Your Honor. I mean, with respect to an audit, yes. I mean, for GSA, an audit means the same thing as an audit means to anyone else, which is a review. It's not sort of a final interpretation of a contract. Because Crowley is a carrier, the other GSA authorities are implicated here as well. Things
Right, so
like
if they're not a
deduction.
carrier, which is the main audit 3726B statutory interpretation question in front of us, if they're not a carrier, you think you can perform an audit, and then here's two things that might happen after. One is you send a demand for payment, and the third would be you actually withhold future payments from them. You seem to be conceding you don't have that latter authority for it if they were a non-carrier. Is that correct, at least?
So, Your Honor, we're not taking a definitive position on the construction of every provision here. What I can say is, we think it's important to the reading of the statute that subsection B includes the word transportation and brings in that broader definition and doesn't include carrier. And that's a difference that any court interpreting the statute would need to take account in looking at those other provisions that you've identified.
Absolutely true. And I think if the government is going to say we have statutory authority to conduct an audit, there should be an explanation of what that audit would entail and what happens next. And I think that's what the fact that there is not a provision that explains what happens next. It doesn't say, for non-carrier audits, all disputes will be funneled to the Contract Disputes Act. It just doesn't seem to fit together when we read the whole statute.
So, Your Honor, I guess one thing I'll say, and again, I apologize, I know I'm way over, but if the court has questions about this broader interpretation of transportation bills, the court doesn't need to reach that because Crowley is a carrier, right? And so I think the court can properly affirm on that narrower basis as well. So you just don't need to get there. The last thing I'll say on the carrier point in particular is to point out some of the implications of Crowley's interpretation of what a carrier is. This is a contract that involves thousands of freight shipments. Crowley's argument is that from shipment to shipment, they get to decide whether or not they count as a carrier, whether or not they're subject to the other requirements for carriers, whether or not they can be audited by GSA. That's an interpretation of the statute that just frankly doesn't make a lot of sense.
They're not saying that they get to decide. They said that you decided by signing a contract with them that specified that carriers are their subcontractors and that they're not carriers.
That's absolutely not what the contract says, Your Honor. So let me point the court to a couple parts of the JA that I think are relevant. One, as I think I've cited previously, the provision that deals with contractor liability and makes Crowley legally responsible. Two, the glossary, which defines both broker and carrier.
What pages are you on?
I'm at 171 defines broker, and I believe it's 177 defines a motor carrier. Next to motor carrier in parentheses, the contract puts contractor. That's the term that the contract uses to refer to Crowley again and again. So I don't think there was any doubt by anyone at the time this was signed that Crowley would be acting as a carrier. And I think that's something that everyone has recognized. GSA's regulations certainly recognize that a transportation provider like Crowley would be subject to audits. DOD's own rules that are about this contract in particular say expressly that it is subject to GSA audits, and the contract itself says that it's subject to independent auditing. So this is not news to Crowley. It's not a surprise. It's something in the contract that Crowley signed. Your Honors, unless the court has further questions, we would ask that you affirm.
All right, thank you. All right, Mr. Boland, we'll give you 3 minutes on rebuttal.
Thank you, Your Honor. I want to hit just a couple quick points. One on the issue of mootness, and Judge Randolph, I appreciate you raising the 11.8 million. I had overlooked that initially in my answer, and that was one of the reasons why we think this is not moot. That money is out there, and even though we are not requesting the money in this action, it's a logical consequence this action and the declaratory relief that we seek. So
This letter, although I don't find any evidence of this, but appears to have been the result of a mediation between GSA and your client that began sometime in the fall. Is that correct?
it followed a mediation, yes.
Was the mediation directed by the district court?
The district court, I think, asked the parties to consider it, and we agreed to pause for 2 or 3 months.
And was the mediator an individual appointed by the district court? Or is there a body? There's a body of mediators on this, in this circuit, and I wondered, the mediator was not someone from the outside, it was someone affiliated in one way or another with the court, correct?
No, Your Honor, there was actually no independent mediator. The parties just interacted together. So it was more of an ADR, just an informal.
So the mediation was just between the parties with no appointed mediator?
That's correct.
Okay.
Yeah, there was no discussion of this letter, but it came after that, after the parties were unable to reach agreement, and we had no advance notice of that letter. But if I may, I want to turn and this, we summarize this on page 6 of our opening brief, but again, we disagree with the government's characterization of the contract. The performance work statement says the contractor's carrier shall pick up and deliver the shipment. It assigns the prime contractor ultimate responsibility for its motor carriers. I think when you read the contract as a whole, it's very clear there's a difference between the prime contractor and the carriers. Judge Garcia, I wanted to address and sort of respond to one of your questions about GSA's process. I would turn your attention to GSA's regulation at 41 CFR 102.118.430. That's the section that talks about what GSA considers to be its post-payment audit. That's the 3726B. And you read that, it covers everything. It's not just an audit, it covers adjudication, offsets, and all of that. And that's, again, that's why we're here. And you're right, we would not have an issue if this was merely, I wouldn't concede GSA had the legal authority to do the audit, but if it was simply an advisory audit and they're just telling Transcom, hey, we think there's an overcharge, we would not object. That's the entire issue here is the fact that they're acting under that authority and then they believe they can unilaterally move forward irrespective of the CDA. I also wanted to go back briefly on the statutory language. Mr. Hazel mentioned that Congress removed language. There was no removal of language in the 1998 amendment, removing carrier from transportation bill. 3726B was an addition in that amendment. And it simply said transportation bills because that's what the entire section was talking about. And the government has pointed to nothing, no hint that Congress thought that it was expanding audits to not just to non-carriers, but to broader contracts outside of those regulated by the ICA. In fact, the legislative history that does exist talks about the opposite. It talks specifically about the historically regulated carriers, and those are the transportation bills that Congress talked about when they enacted the 98 amendment. I would also just remind the court, 3726H talks about a bill under this section. And that alone, to me, means that Congress understood that there's only one type of bill throughout the section of 3726. If they were referring to a certain type and there were different types of bills, they would have referenced those.
So just so that I'm clear, under your reading of the statute, what new authority was created by 3726B? If any.
We do not believe there was any new authority. In fact, I think when you trace the old language, in my view, that language was simply clarifying that it was clarifying what GSA was already doing, or GAO before GSA. The statute talked about GSA's audits, but there was never an affirmative sentence that said that GSA can do the audit. And I think that's all that sentence was doing in subsection B. And there's
Why did Congress need to do that? I mean, why did Congress need to add 3726B then?
I think,
was there any court case that had brought into doubt whether GSA had the authority to audit motor carrier?
To my knowledge, no. I don't know why, but I think the fact that Congress did not even mention this, there's no reference in this. It's not discussed in the summary of the bill, in the preamble. It was all about requiring prepayment audits so that post-payment audits would go down and diminish in importance because they're not cost effective. That was specifically why Congress did this. And so I think the government suggesting that they're pushing the opposite, that this now gives them some blanket right to audit far outside of ever any historical authority is not supported.
All right, we thank you. We will take the matter under advisement.
Thank you, Your Honor.
Yes, please.